Hello and welcome to the Rogers Brief for November 16th, 2024. I'm Adam Rogers. Thank you for watching and thank you for listening. The main case that I want to dig into this week is a Nova Scotia decision out of the Supreme Court. Justice Pierre Muise talking about the electoral boundaries in Cape Breton, well, in Chéticamp specifically. And the Electoral Boundaries Commission came out with a report that the government adopted denying Chéticamp its own boundary. The Fédération Acadienne, Nova Scotia, took them to court and got a decision this week. And so I want to dig into that a little bit later on. But first, a couple of other things I want to get into that are in the news this week. First of all, anybody watch the Mike Tyson, Jake Paul fight last night? I wonder if any litigation might come out of that. How many people, for those that didn't watch, Mike Tyson, 58 years old, didn't look that great. So I was thinking today now, how many people, it's like Joe Biden, how many people knew that he was in this bad a shape? Couldn't even, a little flurry at the beginning of each round. And Jake Paul, 27 years old, big, strong guy, didn't seem to be terribly aggressive against Mike Tyson. Somebody today said it reminded them of Larry Holmes' Ali in 1980, with the elderly Ali and Holmes, his old sparring partner, not wanting to hurt him. Anyway, so see if any litigation comes out of that. I kind of doubt it, but a lot of interests in there. A lot of people making a lot of money off that, and Mike Tyson didn't show up in shape. All right, another thing that was sort of in the news this week was the big Taylor Swift concerts in Toronto. Well, I was reading through CTV News, and I see this story about a couple that had tickets to the Swift concert, one of them, and they broke up. And so the story was all about, well, what are they going to do? And the lawyer that was handling the matter or talking about the matter is Jane Cvijan, Cvijan, from a law firm called M & Co, like the letter M & Co Law in Toronto, talking about, presenting them with three options and they were going to choose something, and didn't get into a great number of the details, but I was reading this story and it was very unclear. Well, it seemed as though there was no actual litigation that had taken place, but of course they needed to resolve it before the concert. So I'm not sure how it became news. It seems to me, because the lawyer herself at the end of the article notes or mentions that she and one of her law partners and their kids are going to the concert as well. It seems to me that the lawyer must have really contacted the media to discuss this interesting case. She didn't give the names of the people, of course, involved, but described the situation and all that stuff. So the three options were that the couple goes together anyway. Secondly, that one buy out the other at the current market rate at that time for the ticket. And then the third option was to sell both tickets and split the proceeds. So the disappointing part of the article was that the lawyer would not reveal which one they chose. We can, I think, eliminate the first one. They probably didn't go together because they wouldn't have gone to see a lawyer if they were in the position where they were ready to go together. Buying out the other at the market rate, probably. Sell and split the proceeds, I kind of doubt that too, because they both wanted to go. Whether they could afford the market rate for, you can buy a ticket at the ticket rate, but then if it goes up thousands of dollars in market rate, maybe they split and just split the proceeds. But again, if they're going to a lawyer figuring out what to do, you would think they would have figured that one out, just split the proceeds. So I think they would have done a buyout. But the problem is this: the market rate changes constantly. So when do you set the market rate? I think that would be a flaw in that plan. Most of the time what happens is this, and then the second one part of it is, who gets to decide? What if they both say, yeah, okay, I'll buy yours for the market rate? So you run into that dilemma. Do you flip a coin, rock, paper, scissors, as to who gets to pick first? The better way, usually in these kind of things, is a clause where one person, and you get to pick whichever person because it doesn't matter in a way, names the price. and it's okay, you either, and then the other person gets to choose whether they will buy the ticket at that price or sell their ticket at that price. And so it encourages a fair offer, because you have to live with it one way or the other. So anyway, we'll see. Hopefully they enjoyed the concert. All right, some other things I was thinking about this week too, sort of recommendations if you're a person that's looking for podcast material. People like to listen to them. I was listening to Malcolm Gladwell's Revisionist History podcast. Malcolm Gladwell, New Yorker writer, and author of books, sold 20 million plus books, has a podcast, really good. It's a number of seasons now, looking at lots of different interesting topics. This year he covered in 2 episodes the college recruitment scandal of a few years ago. You remember that some people went to jail, a lot of celebrities involved, like Lori Loughlin from Full House went to jail. Well, there was one case involving rich guy, I think billionaire, who was a tennis player himself at Brown University. His former teammate was then the coach at Georgetown. Allegations of money being paid to get his daughter on the tennis team, even though she wasn't that great. But then the guy wanted to take it to court, so they hired some top-notch lawyers out of Miami, took it to court, exposed the reciprocal side of it, which is Georgetown and many of these universities were recruiting kids based on athletes based on what their parents' net worth was. They had databases of this, and the internal recruitment and fundraising goals that they set for each person depending on their net worth. And so quite a lot of hypocrisy there. But anyway, the case goes even deeper than that. It's in 2 episodes. So Malcolm Gladwell, Revisionist History, really good one. The other is, I noticed this week, Michael Spratt's column in Canadian Lawyer magazine. You probably have your subscription. But if you're looking for a deep dive and kind of a nice opinion piece, interesting one. So Michael is a former classmate, like I say, is married to also a former classmate, Emily Taman, who ran for the NDP. And Michael, I think, and Emily would both agree or accept the characterization of being NDP supporters and such. And so Michael is talking about the Ford government in Ontario's, rhetoric on crime, Polyev campaign rhetoric on crime, jail not bail, that kind of stuff. And I think foreshadowing what we might see in a campaign from the NDP, from the left generally, as to what that argument is. Fear mongering, I would, characterize it in some ways. I mean, he's not over the top. He's a good writer. That's why I recommend reading it. It's interesting to see what the other perspective is from a well-written source. So Michael Spratt in Canadian Lawyer magazine. If you find that online, I think people can. I don't think you need a subscription to check in on that. So a couple of Nova Scotia cases. I'm going to get to the one about Chéticamp and the Electoral Boundaries Commission. Well, usually every 10 years. This is going to be now every 5 years as a result of that. But there's another case as well. This one was heard by the Court of Appeal in Sydney. They took a couple of days actually, and heard some appeals in Sydney, did some educational sessions and some events down there. So that was a special occasion, first time they've been outside of the city to hear cases. One of them was this one. It was Curry's funeral home, and I don't remember the story. It was the wrong body. It was a very unfortunate situation that was cremated, and so the Funeral Directors Association and Embalmers Association went after Joseph Curry, the owner, and shut him down. And so Joseph Curry took it to court and was successful. And the Funeral Directors and Embalmers Association appealed that decision of Justice Tim Gabriel. 2022 decision, appealed that to the Court of Appeal, and the Court of Appeal upheld the decision. I remember speaking because I was down in Sydney that evening. I didn't hear the appeal argued, but I spoke with some people who did, and they said it was fairly open and shut in its own way. Like nobody really expected it was going to go anyway. But the legislation, the Embalmers and Funeral Directors Act, makes a distinction between funeral home license holders and funeral directors. And the responsibility, so there was a mistake on the medical examiner's side on the body. It wasn't Joseph Curry's fault. But a funeral home license holder is obligated to check again themselves to make sure that the medical examiner has gotten the right body to them. Funeral directors are not. And so it's a clear distinction in the legislation. Court of Appeal upheld that, so that's the end of that situation. Anyway, lots of big impact on Joseph Curry and the operation there. So we'll see. I don't know if there's any civil litigation taking place on the other side of that. Okay, so the last case I wanted to talk about and dig into a little bit is a case decided by Justice Pierre Muise, who was, I think, not coincidentally a French-speaking justice on the Supreme Court of Nova Scotia bench. Now, the decision was released in English. There was no mention or note or anything that it was argued in French, although I know certainly the lawyers for the Fédération Acadienne, Nouvelle-Écosse, Riel Boudreau, Rejean Aucoin, I think Noel and Martin probably all speak French. I know Rejean Aucoin, now Senator Rejean Aucoin, who kind of spearheaded this effort, is French-speaking and has done French cases. So background is that in 2019, every 10 years, the boundaries in Nova Scotia are adjusted. And in 2019, Dr. Colin Dodds, former president of St. Mary's University, chaired a commission that went around and drew up the boundaries for the Nova Scotia election, which is currently taking place. By the way, big decision on the electoral boundaries and a new Acadian riding. I have not heard any of the leaders asked about or answer or voluntarily speak about this. Seems like something that somebody would ask about, but anyway, I digress. The commission in 2019 allowed 7 what they call exceptional districts, and these districts, exceptional means outside of the 25% variance, so that whatever the average population might be, 55 ridings divided by the population of Nova Scotia. If you're more than 25% variance to that, then you need to be adjusted so that you're within the variance. So there was 7 exceptional districts to that, including the Richmond, Argyle, and Clare Acadian districts, but not Chéticamp. There were submissions on behalf of Chéticamp, but they were rejected by the commissions. However, 4 of the 9, so just a minority, disagreed with the majority regarding Chéticamp. So that really put some wind in the sails of the Federation, and they brought a charter challenge under Section 3 of the Charter. And Section 3 is a very short section. It's just the right to vote. It gives people the right to vote and the right to be represented. The right to vote federally and provincially. So there was a reference case that came out of Saskatchewan called Carter back in 1991, went to the Supreme Court of Canada, and it was about boundaries and how all this stuff works. And what does Section 3 of the Charter really mean? Justice Beverly McLaughlin, who was not Chief Justice at the time but later became Chief Justice, said that the right to vote means the right, a reciprocal right in a way, to be represented. Okay, and to be represented is a more complex notion than it might first seem. It's not only, so one element of it, an important element of it, is that there is relative parity. So, fairness, numerically, basically, relative parity of voting power. All right. But that's not the only consideration as you're being represented. There are other factors. There's geographical factors that can be considered, historical factors, community of interests, and minority representation, the importance of having minority representation within the government. So those are also important, and Justice McLaughlin said that the list is not a closed list. There's other things that can be considered as well if they come up and others think of new things. So that was 1991. In 1992, for the first time in Nova Scotia, the Commission carved out districts Argyll, Clare, Richmond, and Preston as having, exceptional status outside the 25% variance, but protecting a community of interest and cultural of cultural significance. Now that changed. 2 reports later, in 2012, under the Dexter government, they legislated that there would be no protected seats. Curious decision from the Dexter government. Can't remember if it was made at the time, if it seemed it could be in their political interest. I thought it was more of a philosophical stance they took at the time, but that decision by the government was challenged in court and it brought to the Court of Appeal in 2017, and it was overturned. So a new commission was struck early. That's why it was 2019 and not 2022 again. So it was struck early because of that. The Court of Appeal said, no, you have to respect this. This is part of Canadian law now, is that these smaller areas that have important historical, cultural, geographical, all these issues, interests, those need to be taken into account. So the Dodds Report in 2019 comes out, 7 ridings, but not Chéticamp. So what does Chéticamp say? Well, and this decision from Justice Muise highlights these elements of Chéticamp. So one of the things that was the problem in the original report was they had Chéticamp at a 0.19 population. So basically just less than 20% of the average population. However, that was just Chéticamp itself, like the village of Chéticamp didn't take into account the wider region in St. Joseph de Moines and Petit de Tang, Marguerite that are close by there. There's other areas close by that would be included in this, as well as Justice Muise points out in Inverness County, which is where Chéticamp's located, in the provincial riding of Inverness, which is Inverness County. First of all, Inverness, the riding, has a 1.02 or 0.01, so even if you just split that in 2, that would be 2 ridings of 0.5, and that's not so bad. There's some of the other ones that are in that neighborhood. Richmond, I think, certainly is there. And it's a huge, large region. Chéticamp is quite isolated geographically, far from the closest number 100 series highway. The weather up there with the Sowets and the amount of snow that they get up there. So Justice Muise took all these into account and said, well, that seems to fit the definition of what representation is supposed to mean according to Section 3 of the Charter as interpreted by the Supreme Court of Canada. So Chéticamp should get its own seat, and that's just fair, as if you're comparing it to other geographical areas, other exceptional seats in Nova Scotia. So interesting. And also he thought that there was, the report didn't really delve in, the 2019 Dodds Report, that is, didn't really delve into these other options. One was, in Inverness County, there are 2,134 people, voters, that registered as being francophones. In Richmond County, it's only 2,064, fewer people. So he said, what about, they could explore an option where the people in Inverness, basically you get 2 MLAs, francophone and a non-francophone, or a francophone and other. Because one of the issues is in the 100 and some years, it's been about 100 years since there's been an Acadian MLA elected in Inverness. Chéticamp's just a smaller part of the riding, so it just hasn't taken place. So that seems to be, and it's harder to access services. for French-speaking constituents. Further away, a lot of people don't speak English, don't speak French within the government offices. So many reasons identified by Justice Muise to have Chéticamp as its own seat. So that's going to happen. Let's see. Well, what are the options now? Of course, the government, which did oppose, I guess that's the government argued in favor of the status quo, or what's happening. Interesting too, because when the Dodds Report came out, the government just accepted it. They didn't question it at the time. This is the McNeil government, 2019. They just accepted it, and the court took note of that doesn't abdicate responsibility in any way. It's still the responsibility of the legislature to adopt the report, or not adopt it, or modify it, however they saw fit. They accepted it, so it was a decision of the government that was being appealed. So theoretically, at this point, there's a few options. One, they can strike another boundary commission and come up with new boundaries. They could do a limited version of that, perhaps, with just the Cape Breton, or just even doing the Chéticamp riding and whatever is directly affected by it. Justice Muise did point out we're 5 years out from the last report already, so it's not the biggest. It wouldn't be the biggest waste of resources to do another report early rather than waiting the usual 10 years. So the government could appeal this as well and reject the notion that they've got to go through the work of creating another riding. By the way, the Justice Muise also pointed out that the cost of an MLA in the whole scheme of government is relatively low, right? So the argument that, well, that's another MLA that's going to cost an office and an MLA salary and so on, and whatever expenses go with that was rejected without a lot of comment. It was just like, well, that's a pretty small relative to the budget of a province. So an appeal, I don't think, of this decision would, it may have some political implications as well of the government rejecting that. Certainly people at Chéticamp wouldn't be happy about it. And maybe the government would just want to accept the decision as it is. It's well done. If they were to appeal, I guess I would say it's because, what basis would you say? Potentially, there's not a lot of evidentiary foundation on the population question. Didn't seem, although because it's not clear where the boundaries might be. But even there, that's really the work for the next commission, is to figure out where those boundaries might be, what the population is, and how much of a variance that is. So there's not a clear lane for a successful appeal of this decision. So I would expect the government to either just accept it, or perhaps even embrace it, and welcome in the new riding and see what kind of new representation and new things can happen up in Chéticamp as a result of having a stronger voice at the provincial table. So anyway, I thought that was an interesting one. A lot of work went into that case. I spoke with Rejean Aucoin about it some time ago, years ago. And so glad to see it turn out in favor with everything that went behind it. All right, and that's kind of what I wanted to cover this week. So thanks everybody for watching, and thank you for listening, and we'll see you next time.